guilty of it. So I know that if he's not in jail, I know that he's able to work and be successful and take care of himself. He's not been a drain on society in terms of that. He's not a lazy man. He's not a stupid man. So I think when he's not in relationships that he should not be in, and this had nothing to do with drugs or alcohol, he's just a good person, and he means well and he does well. And this was not a relationship either. There was not a relationship between these two. That was more of a working thing.
That's what's weird, is because in the criminal complaint, the probable cause, which comes from the police report, it identifies her as a girlfriend. It identifies her as something over a period of time, but this could have been something what could have occurred over multiple other incident dates.
And I suspect that I'm just suspecting when Attorney Renicky was going through this and charging this out or whatever, maybe he had contact with the victim in this case, and maybe she also said, I was not in a relationship with him at this time period.
Well, and I will go over to the district attorney now to ask from their perspective, because I'm going to say quite clearly in the criminal complaint, which comes from the police reports, which comes from their investigation, which comes from the statements from the witnesses and the victims, it states she is the girlfriend. It states that on September 6, 2024, I, Deputy Henry, was requested by dispatch to respond to. Dispatch advised that probation agent Lineweber was at the residence looking into allegations that Bradley Scheuer assaulted his girlfriend, JEC, last night. And if you go down, it says in the middle of the paragraph that she was worried about further retaliation from Bradley, as he told her numerous times that he knows people and he can hurt her even if he's in prison. And where else did it say? He threatened to burn her alive in the camper. Where else does it say other things like that? But
the defense agrees that that's in the complaint, but again, I don't think that she's saying that she was in a relationship with him. The only thing that I had read from it is they were investigating allegations that Scheuer assaulted his girlfriend.
Schmidt?
I'm the one who charged it. The reason it doesn't have the domestic abuse surcharge is boyfriend, girlfriend is not something that creates the domestic abuse surcharge in Wisconsin. It's whether they're married or reside together or have children together. Being boyfriend and girlfriend does not make it a domestic abuse offense in Wisconsin. That is why I did not.
Well, and quite honestly, whether or not he's guilty of the charge and how it is charged doesn't really matter if it's boyfriend or girlfriend. Well, granted, if it is a girlfriend, you probably should care for that person and not want to harm them, but you shouldn't want to harm anyone. So, Mr. Davis, I don't know. I don't know if it's a girlfriend. I don't know if it's not a girlfriend. I don't have the victim here. I don't believe in court here today. I just know what was reported to law enforcement. And I don't believe that law enforcement would make something up and put that in a police report. And that's where we get the criminal complaints and the information from.
Well, just
law enforcement.
In my argument, Judge, my client was not in a relationship with her when this occurred. And it's my belief that I think that she did live in Minnesota too at the time. They were not residing together. At least that's what I believe. And so I don't believe it was a domestic relationship as defined by the statute. But in any event, I'll concur. I don't care if a person's in a domestic relationship or not. If you touch someone without their consent and it causes them pain, it's a crime, and it doesn't make it any, well, I guess I agree with you a little bit on that too. I guess if you're in a relationship with somebody, there's a tie where you wouldn't want to hurt that person, but still, it's not good, and it's why there's a law, and that's why now he's convicted of a misdemeanor because of it.
And I'll also point you to page 3 of the criminal complaint, where JEC also stated there have been times while they were staying at her residence in Minnesota where Scheuer has struck her, but she has never reported it. JEC stated when Scheuer had kicked the front of her knee last night, he told her that it only takes 10 pounds of pressure to break it, and she will not be walking out of there. She would be crawling out.
And again, I think the criminal complaint in Wisconsin, they're mere allegations. I think in the discovery, or if you get body cam footage, or you get also stuff from the victims writing and themselves, a lot of the times, I would say most times it's different from what's in a criminal complaint.
I'm just pointing to the fact that JEC was saying that there was some type of relationship, whether or not
Doesn't give a time, but I'm just saying, I don't believe that this was a domestic relationship as defined by the statute, but in the state has not charged him as such. But in any event, going forward, Judge, he's got the 164 days that he's sat. I know that I think the jail does have an effect on most people. I've had clients where they don't really care. Bradley does care. I know that he's climbing the walls. I know that he'd rather be out working and just doing normal things that people do out in the community rather than sitting inside the jail cell. And so for that, I think this has affected him. Again, I've got clients where they really don't care. Jail doesn't scare them. A prison doesn't scare them. But in this case, Bradley, it does. And so I'd ask the court to consider that 1 month to the 3 month. I'd ask that be time served on that. And again, probation, it's not that I don't think probation is, I mean, it's not, I don't think that probation is not a good thing in this case, but with regard to for drugs and alcohol, I think that certainly I think probation is important. People can have some kind of monitoring, and I think they can also get involved in a lot of treatment, whether it's inpatient or outpatient through the probation agents. But in this case, he's never going to be having contact with JC again. And that whatever relationship the court wants to think that is, there will never be a relationship between those two. And for that reasons, I'd ask the court to consider my argument. Thank you very much.
Thank you, Mr. Davis. Mr. Scheuer, I'm now going to give you an opportunity to make any statement that you wish to make. You don't have to make a statement. You don't have to say a thing, but it's your only opportunity to clear anything up, to let me know anything about yourself that you wish for me to know, fill in gaps, fill in holes, whatever you wish to do. But again, you do not have to make any statement if you do not wish to.
I don't know if you ever read this statement. I wrote a statement of all the work I've done for her when I was at her house. I did a lot of work for her. My job for her was.
I'm going to stop you right there. First, I don't believe that was filed with the court, so I have not read it.
Okay.
Second, you just need to speak a little bit slower. My court reporter takes everything down, and it's very hard to take things down when we speak really fast, okay?
You can read it if you want. It's your.
Well, that looks like a lot of words.
Yeah, I don't know, I could give it to the courts,
And
but
here's the question though. What relevance does it have what work he did for this individual?
Judge, I just think he wanted to impress upon you that the relationship was that of a working relationship. I think we've already got to the point.
What relevance does that even have?
Well, I think it does, because the court brought up multiple occasions that.
I'm just bringing up what's been alleged in the criminal complaint and how it was portrayed by JEC to law enforcement and how it was placed in the police reports. And Mr. Scheuer was asked at the date of the incident as well, and he didn't state counter statements to that fact. And then it was charged that way.
Judge, I'm not going to get involved. It says allocution. I really don't know what the limits are on an allocution, so I'll just stay out of that.
He can tell me anything he wants to know, but I don't need to be read every time you've done work for JEC and what it was. If you've done a lot of work for JEC, you can let me know you've done a lot of work for JEC and give me an idea of what it is you did for her.
I did a lot of work for her. I put up garage doors, put up garage door openers, cut down trees because I was supposed to roof her house. The whole key was to roof her house. That was the whole key of that, because she was dating my best friend. That's how I met her. She was with my best friend. That's how I met her. And then I went over to roof her house, and I told her I wouldn't roof it until I cut down all these trees. And I cut down some pretty big trees. And otherwise, that's about all I got to say. But a lot of things she did when I was there, she would get upset. Wrong word, whatever. She would get upset at you. And I've had her throw oil on me. I've had her throw water on me. I've had her get mad. She get mad if you said the wrong word or did the wrong thing. She abused me with a fence post. And I got pictures of that.
So did you ever sleep with her, have sexual relations?
Yes.
Yes, so that answers my question. That's all I needed to know with regards to girlfriend, no girlfriend relationship, no relationship. Doesn't matter if she was dating your best friend or not, you slept with her. So it means to her that you had some type of relationship.
Yeah,
Closer
sex buddy.
than just, because I'm gonna tell you, I don't sleep with my roofing guy. I don't sleep with the guy that fixes my garage doors. So it means that it was a little bit different than just a hired hand. All right. But anything else you want to let me know?
No, I'm good.
Okay. So all I heard there was excuses, 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 blame the victim, victim blaming, more victim blaming, and excuses. That's all I heard from you, Mr. Scheuer. I didn't hear any remorse. I didn't hear anything about that you're sorry that this happened. You should have never laid your hands upon her. No matter what, I'm going to tell you, even if the sky was purple and grass was blue and she got mad at everything that you did and she threw a brick at your head and caused you a concussion 6 months ago, even if she did that, okay? You had absolutely zero right, zero legal right, zero moral right, ethical right, all the rights to lay your hands upon her on September 6, 2024. Doesn't matter what she did or didn't do prior to that date, you had no right to touch her in any way, shape, or form. You had no right to lay your hands upon her. And some of these statements that she stated that you told her to law enforcement, OMG, like they are out of this world crazy. A crazy man says those things. How much pressure it takes to break a kneecap, and that she will be walking, what else did you say? I read it on the record already. These statements, these are more than just threats of harm. They're threats of egregious harm, more than substantial harm, malice, total torture. And you have no remorse. And you're not even looking at me right now. You're looking some other way because you're pissed off because I am telling you like it is. And you're mad because you wanted it to go your way. You wanted it to go your way. And it doesn't matter. It truly doesn't matter in the scheme of life and in the scheme of the legal realm, whether or not she is your girlfriend, or if she is a friend, or if she is a person on the street, or if she is somebody that hired you. In the sense of the legal word, you had zero right to place your hands upon her and to batter her. No right, but you did. Now, so that makes this serious. The fact that you have the criminal history that you do, you have an extensive criminal history, you have a crime that you're going to be sentenced for, not today. I'm not sentencing you today on that. For one, because you don't have an attorney, and you probably can apply for the public defender now since you are in custody. You don't have a job. I don't think you have income coming in, so you probably will qualify. And you need an attorney because the recommendation is prison. So that could be scary. And the second reason is because I think you need some time to let everything sink in, because this is serious. The other crime in the 23 CF 213 is significantly more serious because someone died. And you sit there cocked back in your chair like it doesn't matter. And you have an attorney who's excellent, by the way, who's excellent. An excellent attorney can't get the most guilty person out of the charges. Because you don't just catch charges, you commit crimes to get those charges. You committed crimes to be charged with these criminal acts. I have to look at the community and protecting the community. And Mr. Schmidt was dead on the money when he said, 3 days. I sentenced you to probation in 3 days. Within 3 days, you committed these crimes. And you're reading something, and Mr. Davis, I don't like that you're writing stuff to him while I'm doing it, or whatever's happening, because he's not paying attention.
I'm paying attention. I can hear.
No, because quite honestly, people can't really multitask. You can't read and listen at the same time. It's proven. All right. So this is important because this is your life. So I don't know what is more important than incarcerated, or whether or not you can walk free, or whether or not in another case you're going to go to prison, or whether or not you can have jail, or what's going to happen here and there. Because this moment is important. It should be the most important moment of your life. Three days. It took you 3 days on probation before you were arrested for these charges. Okay, Mr. Davis, I don't know what that is. Can you please turn it around, because he's not paying attention.
Sorry, Judge, I didn't write that. That's not my writing. But no, I don't know what I was just looking because it was there. So I'm sorry.
I don't know what it is. If it's a statement and he wants to read it, he can surely read it, and I will wait and I will hear.
Oh, it's not a statement.
Because this is extremely important. And I believe it's important. It's important to you. It's important to me. It's important to the state. It's important to the victim. It's important to the entire justice system. Is there anything that I need to know?
No.
Because you have the floor.
If there's any additional thing you want to say, you can say it now.
No, I'm not saying
Well,
nothing.
apparently whatever
Obviously,
on
she's
that
right,
yellow
I'm wrong.
paper is more important than hearing what's going to happen in his case. So in 23 CF 213, which was a very serious matter in which an individual actually did die and a firearm was involved, the court placed you on probation with a withheld sentence. Within 3 days, you were arrested on these allegations. Within 3 days. And then you were in custody within 3 days of being on probation. That doesn't bode well for your case. And the fact that you're not taking this seriously, you're not showing any remorse, that you're blaming the victim, it's not telling the court that you are taking this seriously and that you are accountable. So based upon all of that, and with the totality of everything involved in this case, with regards to count 3 battery, the court is sentencing you to 9 months of incarceration consecutive to any other sentence that you will serve. $443 in fines and fees. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. If you fail to pay your fines and fees, not only will you have a civil judgment entered against you, because you're always going to owe it, but I will issue a warrant, and you most likely will sit up to 6 months in jail for not paying. I need your DNA. The jail will make sure that they take your DNA with this criminal charge you may be able to have it expunged from the system through a written letter to the Department of Justice. That is to the Department of Justice, not to this court. This is not a felony. This is a misdemeanor. Mr. Schmidt, what am I missing?
We'll just ask Lieutenant Mogen to get us the credit. We'll submit it to the court, and if there's any disagreement, then the defense can file a motion. Does that sound?
Well, I believe
Agreeable.
that Mr. Scheuer believes it's 164 days. I will give 164, and I will give Mr. Davis 7 days to get any different number.
Works for me.
The 164 days credit. Mr. Davis, what am I missing?
Nothing, Your Honor. Nothing further, Your Honor. Thank you very much.
All right, thank you. Then we are adjourned on that matter. I'm going to call the other case. We are setting it for a different date and time. I believe that for all purposes, it's necessary.
Your Honor, may I be excused now?
You are excused.
Thank you.
Yes. We will go on the record in the matter 23 CF 213, State of Wisconsin versus Bradley Scheuer. The state appears through District Attorney Kevin Schmidt in person. Mr. Scheuer appears in person in custody without counsel. We're set here today in this matter for a sentencing hearing on revocation. Mr. Scheuer was convicted of possessing a firearm as a convicted felon, a G felony. He was placed on probation with a withheld sentence back on September 3rd, 2024. He was arrested on new charges in which he has just been sentenced just recently today. He was placed on probation and was on probation for 3 days before he was arrested on new charges. He was revoked on this case and these charges. The court has received a revocation order and warrant packet. It does recommend a prison sentence. Mr. Scheuer does not have counsel. Mr. Scheuer, this is a serious case and a serious matter. I know that you indicated that you wish to represent yourself off the record. However, this again is a serious case with a recommendation for prison. Therefore, I would strongly encourage that you contact the public defender's office and you apply to see if you qualify. You have been in custody for a significant amount of time. Therefore, you may qualify for a public defender. I'm going to reschedule this matter for a different date and time to give you an opportunity to see if you qualify. If you do not qualify, then you can apply for a court-appointed attorney, and one could be appointed to you with a deposit. You have done that previously, and your son has put down a deposit for you. Again, this is a very serious matter with a recommendation of prison. So I'm going to give some time. I believe we need at least an hour. The closest I can get it in is March 24th at 1:15 on a Schmidt week, because I'm leaving it on a Schmidt week, correct? Or am I okay to place it on an ADA week?
Either works for me. I think either of us can do it.
Okay, so then let me look.
Whatever's convenient to the court.
How about March 17th at 10:30? March 17th at 10:30, that's an ADA week. That gives you plenty of time to apply for a public defender. Again, if you do not qualify, you can apply for a court-appointed attorney and have a deposit, and one would be appointed to you. Thank you. We are adjourned.